So Alabama has a new chemical castration law. It's what I call the hasta libido law, or the adios gruesome twosome law. The law is new to Alabama, but castration as punishment for a crime has existed for millennia. It's part of a long legal history, and the theory behind the legal history is, oh, let's punish the body part that offends. Like it was the body part that did it. We can see this history even in the Bible. The Bible says, if thy right eye offends thee, pluck it out. It also says, if thy hand offends thee, cut it off and cast it from thee. Under this same theory, a thief who, steals a loaf of bread is subject to having his hand cut off. Why? Well, because it was the hand that offended. And in America, there's a long legal history of physical, we're not talking chemical, physical castration. Let's cut her off. In fact, Thomas Jefferson himself established laws that allowed for the actual physical castration of people convicted of certain crimes. And California, not to be undone, they were physically castrating people generations before Alabama even had thought of the idea. So, what about Alabama's law? Alabama's law is that male sex offenders who are convicted of crimes against children who are under the age of 13 must be chemically castrated if they're going to obtain parole. So the law's a little screwy, and I'm going to talk about this here. First off, it doesn't apply to some of the situations you would think, wow, this is a guy who ought to get chemically castrated. For example, the most serious crimes in Alabama, which are called Class A and B felonies, ranges of up to life in prison, and for the B's, 20 on up. But guys who commit the most serious sexual crimes against children under 12, well, they're not eligible for parole. They get what I call a roach motel sentence. In other words, they check into the penitentiary, they don't check out until they've served their entire time. This law doesn't apply to them because they don't get parole. So who else doesn't it apply to? Well, it doesn't apply to women. It only applies to men. And there's only a very narrow bandwidth of crimes that fall in this category. I can think of two that I suspect would apply. One is Herbert the pervert, the guy who says, hey, little girl, I got a puppy and some candy in the back of my van. Well, a guy who's soliciting a child for sexual activities in that manner, who's enticing a child, would apply to him because that's a Class C felony. Another kind of case is the use of a computer for solicitation of a child. Again, it would have to be a child under 13. And, that's the to catch a pedophile situation. Those guys, if they go to prison and ever want to hope to get out on parole, they'd be subject to the law. Now, there's situations where you'd think the law would apply, but it just doesn't. Let me give you an example. So Flash the Flasher, let's assume it's his first time offense, and he goes out and he flashes little 7-year-old Sally Smith. He gets arrested, he gets convicted. Does it apply? Nope. He does his time, he gets out, but he's like, that was kind of fun. Let me go do it again. So this time he goes and flashes little 7-year-old Molly Brown. He's caught. He's convicted a second time. Does chemical castration apply to him? Nope. Why not? In Alabama, a first or second offense of indecent exposure is a misdemeanor, and this law applies to felonies. Now, let's say that, Flash the Flasher goes out this time, and he flashes little 12-year-old, Becky Thatcher. Now, the law may apply to him. Assuming he's convicted of a third offense, it would kick in because under Alabama law, a third offense for indecent exposure is a Class C felony, and it would apply or may apply. Now, of course, if Flash wanted to avoid it, he'd just flash children who are 13 and above. But let's hope that he's not that smart. So, I've said may apply. Why do I say may apply instead of it will apply? The law says that if you refuse to take the medicine, it's considered a violation of parole. And so a guy like Flash who says, no, you're not going to juice me oranges. Well, if he refuses to take it, they're not going to parole him, and he can just do his straight time to avoid it. And as I've said, they can just avoid it by going, So I think that the law's not going to be applied a lot. But I also think that the very few times that the law is imposed, we're going to get a bunch of lawsuits. There's going to be problems. Well, what kind of problems? Let me go into at least a few of them. I suspect there's going to be both criminal and civil lawsuits that result from this. You're forcing somebody, or trying to force somebody to take a drug. And let's say there's side effects from the drug. Somebody has a stroke or a heart attack, and they've been made to take the drug by the state of Alabama. I'm sure there's some plaintiff's lawyer out there who's going to be rubbing his hands going, ooh, I'm going to get me a new mansion. Thank you, Alabama. Now, there's other problems. It applies only to men. So a defense lawyer is probably going to say, ooh, I think I see an equal protection argument, and raise some argument that way. There's many problems, but one of the other problems is that the law says that the judge decides whether or not to apply this law. I can't speak for you, but when I'm talking about, taking drugs, it's my doctor who says, oh, you need to take this drug. It's not some judge. Is the judge qualified? Well, we'll see. I expect there's going to be litigation in that department as well. But I hope that you, or any of your family members, aren't in any kind of a legal jam. But if you are and you're in trouble here in North Alabama, you want our help, just give us a call here at Siegel & Siegel. I'm Andy Siegel. I practice with Sandra Siegel, my wife. By the way, if you like this video, if you'll give us the old thumbs up, and if you want to see more of these videos as they come out, just hit the subscribe button. Thanks for watching.